Welcome, everybody. My name's Maria Lee, and I am the co-convener and co-editor of Current Legal Problems, which is a lecture series and a publication which has been running in UCL Faculty of Laws since 1946. My job today is just to welcome you all to UCL and also to introduce our chair. Our chair is Professor Mike Raco. He is Professor of Urban Governance and Development and also Head of School in the Bartlett School of Planning here at UCL. His background is in geography and urban studies, and he's previously lectured at the Universities of Glasgow, Reading, and at King's College London. He's published widely and very wonderfully, as many of you will know, in urban governance and regeneration, on the new contractualism, the regulation of the real estate sector, the politics of urban economic development. I won't run through all of his many and wonderful publications. I will simply leave it to Mike and very much look forward to hearing from Mike and from Ed today. Thank you.
Thank you. Well, thank you very much for the very kind words, Maria, and also for inviting me to chair the session this evening. Thank you in this current legal problems lecture series that is run here in the law faculty. Our speaker tonight is Dr. Edward Mitchell, who's a lecturer in the law school at the University of Essex. Ed's PhD work was based at the University of Sheffield before we moved to Essex, and for a number of years, Ed has been working on issues around contractualism, legality, but also thinking about the relationship between the public interest, how you convert public interest demands into contracts, and how you use those contracts to govern actors beyond the state. And some of that work, I think, is extremely innovative, lively work that also, as we're going to hear tonight, is built on and embedded in detailed, proper research on places, which I think is also a huge part of what one should be doing as a legal scholar or planning scholar in terms of the kinds of work that we do. Ed is speaking tonight on the topic of contracting in the public interest, re-examining the role of contracts in contemporary town planning processes. And so we're going to hear tonight about some of the work he's been doing out in the field and reflecting on that. The talk will last for about 45 minutes, and then there'll be time for discussion and questions, and then a drink afterwards, as Maria was saying. So over to you, Ed.
Thank you for the introduction, Mike. It's always interesting to hear other people summarising what you've been doing, and if I could have summarised it like that, I'd have been happy. Thank you for agreeing to chair this evening. I've learnt lots from your research over the years, so I'm really delighted you've agreed to chair. Hello, everybody. Hello to everybody watching online. I know you said hello to everybody at home, but that feels a little bit too much like a TV personality's catchphrase. Hello to everybody at home. But anyway, this hybrid format is great, isn't it? It does mean I get the chance to do one special greeting. My 4-year-old daughter asked me why I wasn't going to be home when she goes to bed tonight. So I told her where I'd be. She found out that there's a video that she could watch me on. So hi, Flo. I hope you had a good afternoon. I dare say, as children tend to be, she might be my toughest inquisitor tomorrow morning. Why is a tough question, isn't it? Why were you talking like that, Daddy? Why did you have those funny clothes on, Daddy? I'm sure I'll be asked all those sorts of things in the morning. Why is a tough question. But anyway, hello. Everybody, thank you all for coming. When Maria asked me to contribute to this series, I thought, wow, thanks Maria. I was honoured to be asked. I thought about the other contributors to this series and wondered if I belong in that company. I still do, but I'm thrilled to have been asked to contribute. So my first thought, like I say, was, wow, thanks, Maria. But then Maria mentioned the date and the time. Thursday, the 14th of December at 6 p.m. Doesn't the whole UK higher education sector pack up for the Christmas vacation on Friday, the 15th of December? People are going to be doing all sorts of work-related socialising that week. I thought, again, thanks, Maria. So if you're sat there thinking, I've already been out after work twice this week, when's this guy going to finish? Blame Maria. But I hope it won't get to that point. I don't have any jokes to keep you entertained. Most of my jokes these days are for a 4-year-old audience, and they're of the what made the tomato blush variety. And I wouldn't be confident rolling those out even to a 4-year-old audience without some juggling or something like that as a sideline in light entertainment. So I've tuned into some current legal problems lectures before, and I've never seen anyone juggling. So I'm not going to go there, at least at this stage. Now, at this point, you might be thinking, like my daughter, why? Why is he here talking about jokes and juggling? It's a good question. Why am I here? Well, I'm here to talk about planning law and contract scholarship. To be specific, I'm here to talk about planning obligations and Section 106 agreements. As everyone here undoubtedly knows, the grant of planning permission usually increases land's market value, which provides an opportunity for a local planning authority, an LPA, to capture a portion of that uplift to fund local infrastructure and other public service provision. And this is also a way to internalise the social and environmental costs of property development. New development might, for example, necessitate local healthcare and education provision, and the developer can be asked to contribute the required funds to meet those needs. LPAs can attempt to secure these developer contributions, of course, by negotiating planning obligations with developers made pursuant to Section 106(1) of the Town and Country Planning Act 1990, which usually take a contractual form in a Section 106 agreement. There are alternative ways of securing these developer contributions, of course. LPAs can seek funding for infrastructure provision by imposing a charge under the Community Infrastructure Levy, for example, although not many local authorities have done this. More recently, the Levelling Up and Regeneration Act 2023 empowers the Secretary of State to make regulations for a new infrastructure levy that, if introduced, LPAs would have to implement. These proposals would reduce the role of Section 106 agreements, although they do foresee an ongoing role for planning obligations secured by Section 106 agreements. But implementing this levy will take a long time if that's the route that the government decides to go down. So Section 106 agreements will continue to shape public and private spaces for many years to come. But I'm not telling you anything new right now, am I? What's interesting about this? Well, I'm going to discuss Section 106 agreements by looking at 2 case studies. And I'm going to draw some conclusions from that empirical material about what Section 106 agreements tell us about planning practices in England. So my starting premise is that contract might work in planning practice to offer administrative efficiency and secure binding developer commitments. But while obligations in Section 106 agreements are often successfully delivered, there are significant gaps in existing practice. One source of tension in current planning processes relates to the role of private companies. As Maria's pointed out in some of her work, LPAs currently lack resources to provide essential public services, so depend on private developers to fill this gap. LPA officers must thus often act as contract managers, tasked with negotiating the delivery of these services in the public interest. And the contractualization of planning processes embeds what Alexander Lord and Mark Tuja-Jones have called the normalization of market logics in planning decision-making. This is the idea that private profit, wealth creation, and strong investment returns now define the public interest. And there are other problems with the use of contract in public service provision. In a broader urban development context, Mike has explained how contracts with private developers sometimes lock public bodies into relationships that don't produce socially desirable outcomes. Scholars working in fields like rail franchising, contracting out of probation services and IT services have noted the enormous expense of some of these arrangements. And of particular relevance for me is Peter Vincent Jones's study of contract regimes that the UK government created to pursue public policy objectives in the early 2000s. Vincent Jones's research draws on Ian McNeill's relational contract theory to show why these contracting regimes failed to fulfill the government's objectives. McNeil's work also helps me by providing a framework of ideas that we can use to analyse Section 106 agreements. For McNeil, each contractual exchange involves an interplay of discrete and relational behavioural norms. More discrete norms, such as planning the exchange and consenting to the limitation of one's future choices, are necessary to structure contractual relations and provide fixed reference points for future conduct. But these discrete behavioural norms coexist in McNeil's relational contract theory and McNeil's theoretical framework with more relational behavioural norms such as flexibility, solidarity, and reciprocity, which are often necessary to sustain long-term contractual relations. And the Section 106 agreements I'll talk about appear to be the product of rigorous planning of the contract relations and a desire to impose strict rules to govern those relations. And I argue that this creates the impression of highly discrete and very complete contractual arrangements. But I'm also mindful that transaction costs economics has shown that contract counterparties cannot plan fully because of imperfect information and inherent uncertainty at the negotiation stage, so attempt to create safeguards against opportunistic behaviour by their counterparts. Focusing on contractual safeguards is important when thinking about the bindingness of each part of a Section 106 agreement. As I'll show, some parts of Section 106 agreements might have, to borrow Catherine Mitchell's phrase, the substance of a contract, whereas other parts contain only contractual trappings. I ask when the safeguards in Section 106 agreements might facilitate monitoring and enable sanctioning of defective performance, but I also investigate circumstances in which those safeguards might sometimes act more symbolically, deployed to signal a general commitment to broad policy objectives rather than for enforcement or sanctioning purposes. But contracts are also, of course, artifacts of specific social processes. Section 106 agreements are dense objects in their own right, and I explore how LPAs and developers can deploy an agreement's hefty materiality and symbolic power at strategic moments to move a development process forward. Of course, recent socio-legal and planning scholarship examines the materiality of different types of documents, investigating their role in shaping social relations, and that work provides extremely important insights, but none of it does so while also drawing on McNeil's relational contract theory to show how specific contract provisions play a crucial role in shaping both the counterparties' relations and wider community relations. So taking this approach enables me to show that these Section 106 agreements look highly prescriptive and that this appearance facilitates certain property development processes. But I'll also show that these agreements are flexible enough to be adapted in accordance with the preferences of the private companies to which LPAs have transferred decision-making powers relating to public service delivery. But let's move on to my case studies to think these things through. That's not doing anything, is it?
Okay, there you go.
There we go. Minor technical hitch there. The first case study I'm going to look at involves a residential development of around 150 homes that a national house builder is currently constructing in Colchester in eastern England. When the developer received planning permission for this development, it signed a Section 106 agreement with Colchester City Council and Essex County Council, which obliges the developer to make a financial contribution to the County Council's provision of education services and financial contributions to the City Council for the provision of healthcare services and community buildings, installation of information boards and record keeping at a local historic site, improvements to visitor facilities at that site, and ecological mitigation works at local special protection areas. And the agreement also obliges the developer to provide on-site affordable housing and public amenity areas. So far, so mundane. These are everyday contributions that LPA seek to secure from house builders all the time throughout England. The contractual arrangements set out in Section 106 agreements often establish a mechanism to secure the delivery of a predictable range of developer contributions. And Vincent Jones points out that various public contract regimes exist for procedural purposes, and Section 106 agreements tend to have a similarly administrative and bureaucratic nature. But the level of detail in these agreements is frankly quite intense. To secure the provision of the obligations I just described, the Colchester Section 106 agreement first requires the developer to provide notice of its intention to commence development at least 20 working days before actual commencement. The developer then agrees to pay the ecological mitigation contribution and provide various documents prior to commencement. Next, the developer states it will give the two councils at least 10 working days notice of the expected occupation of the first new dwelling. And after that, the developer states that it won't allow the occupation of any new dwellings until Colchester Council has approved more documents and until the two councils have respectively received the full healthcare contribution and half the education contribution. After that, the Section 106 agreement says that the developer shouldn't allow the occupation of the 11th dwelling until Colchester Council has received the archaeological park and the community buildings contributions, and it shouldn't allow the occupation of the 37th dwelling until the council has received the archaeological information and record-keeping contributions. Alongside this, the developer also agrees to provide Essex County Council with 2 weeks' notice of the expected occupation of the 50th dwelling and to pay the county council the remainder of the education contribution before occupation of that dwelling. Thereafter, the developer promises to inform Colchester Council of the first occupation of 60% of the market dwellings within 14 days of reaching that occupancy level, but not to allow the occupation of more than 70% of the market dwellings unless the affordable housing has been made ready for occupation and transferred to an approved affordable housing provider. There's more. I could keep going. This detail is pretty intense. I'll spare you that intense detail. You get the idea. This is dense. This is intricate. So what's going on here? Well, this looks like an attempt to create a highly discrete contractual arrangement. This Section 106 agreement looks like a set of rules created to guide the parties through a specific sequence of actions. But my argument is that these appearances can sometimes be deceptive. These agreements might not be doing what we think they're doing. And one way we can think about that is by looking at monitoring and enforcement. The sequence of actions in the agreement I just described might be intended to enable the LPA to gain information about the developer's activities and to monitor and enforce the achievement of public policy objectives. Perhaps the parties agreed, for example, that the developer would pay the community buildings contribution before occupation of the 11th dwelling and the archaeological contribution before the occupation of the 37th dwelling to create reference points against which to monitor the developer's behaviour. Section 106(5) of the Town and Country Planning Act 1990 enables an LPA to enforce a requirement in a planning obligation by injunction. So rather than conceiving of a Section 106 agreement as a procedural script, perhaps an alternative image might evoke the sense that the parties are empowering the LPA to erect roadblocks at pre-agreed milestones to prevent the developer's passage along the agreed development pathway unless the developer satisfies certain commitments. That might all sound reasonable. In contractualized planning processes like this, planners need to be contract managers. Gemma Burgess and Sarah Monk have noted that closer monitoring tends to correlate to fuller delivery of planning obligations. But they also note that the effectiveness of LPA monitoring practices is highly variable, with particular challenges evident in rural locations with geographically dispersed Section 106 agreements and in urban settings where LPAs deal with high numbers of agreements. I don't know about everybody here, but that sounds like a lot of the country to me. And acquiring and processing contractual information is expensive. An LPA might not, for example, have the resources to gather all the information envisaged in a Section 106 agreement like the one I've been talking about. And if an LPA does gather that information, that sort of information, does it have the resources to do anything meaningful with it? But more research, I think, is needed to enable us to understand if, when, and how LPAs gather and then use the type of monitoring information theoretically made accessible through the text of a Section 106 agreement. Further research might also investigate the use of enforcement powers in Section 106 agreements. LPAs do seek, or at least threaten to seek, injunctions to compel developers to perform their obligations, with recent press reports indicating that these enforcement actions can encourage more complete performance. In the case I've been discussing, the council might have sought an injunction if the developer had failed to provide one of those substantial contributions, although our knowledge about how often and how successfully LPAs do this is patchy. But it seems unlikely that an LPA would seek an injunction if a developer failed to make a smaller contribution like the archaeological or ecological mitigation contributions in the example I've been talking about. And this lack of realistic enforcement powers is something to think about. We might ask ourselves about the cultural effects of this. David Feldman argues that legislation that contains declaratory, promissory, aspirational, or rhetorical statements rather than legally binding rules can weaken respect for legislation and so damage its psychological power. We need to keep that in mind when thinking about a Section 106 agreement that looks like a prescriptive set of rules. And while we need more information about the extent to which Section 106 agreements empower LPAs to secure public policy objectives, we might be able to reach tentative conclusions about what this type of agreement might offer a developer. The travel-based metaphor that I used earlier might help. The sequence of triggering events in the Section 106 agreement I described is a mechanism that allows the developer to control when it reaches a milestone that would trigger its next obligation. This is a means to control the pace of development and the rate of expenditure and their cash flow. As Tuna Tassentock and Martin van den Herk point out, private actors tend to seek long-term certainty provided by a technocratic bureaucracy to secure risk-free investments. And a Section 106 agreement like the one I've been discussing fits with these prevailing tendencies by providing developers and investors with tools to control the delivery of the obligations attached to a development site. Vague monitoring and enforcement powers probably don't concern a developer that might be keen to show an investor that the public policy objectives and an LPA's powers in a Section 106 agreement don't threaten a good investment opportunity. But this matters because a Section 106 agreement often looks like a detailed contract empowering a public body to hold a private actor to the public body's vision of the public interest. But that's one set of insights into how Section 106 agreements might be working. I'll discuss another development now, because I think this development can show us more about how vague and one-sided clauses might still be substantial enough to enroll key public decision makers into planning processes while remaining flexible enough to allow private actors to retain control over those processes. And this development involved proposals in Seven Sisters, North London. The site consisted of the former Ward's department store, some council-owned properties, and various private retail and residential premises. A range of different individuals, businesses, and other organisations separately owned the land that constituted this site. Haringey Borough Council, the London borough responsible for the area, entered into a conditional development agreement in 2007 with a national developer, national property developer, in which Haringey agreed to use its compulsory purchase powers to acquire land on the development site and to transfer that land to the developer. In return, the developer agreed to carry out the development subject to various preconditions, including its ability to forecast a commercially suitable profit. This development agreement was, therefore, a type of land acquisition agreement entered into by the property owning part of Haringey council rather than a Section 106 agreement created for town planning purposes. But the Seven Sisters development is interesting precisely because the land acquisition process ran alongside the planning process. There was a Section 106 agreement created for the development, and it played an important role in both processes. As you can see, in 2008, Haringey granted the developer planning permission, but the Court of Appeal quashed that decision because Haringey had failed when it granted planning permission to discharge its duty under Section 71(1) of the Race Relations Act 1976 to pay due regard to the effect of its decision upon equality of opportunity and good relations amongst persons of different racial groups. I dare say some of you know which development I'm talking about here. The Seven Sisters development involved proposals relating to the Seven Sisters Market, which is also known as El Pueblito Peza, or the Latin Village. Most traders at the market are from Latin America or Spanish speaking, and the multicultural nature of the market and its importance to the community had a significant effect in shaping the land acquisition process and the planning process for this development. But by the time the developer had submitted a new planning application for the development in May 2012, Section 149 of the Equality Act 2012 had replaced Section 71(1) of the Race Relations Act 1976 and imposed a new duty on public bodies to have due regard when making decisions to the need to eliminate discrimination, to promote equality of opportunity, and to encourage good community relations. To discharge this duty when considering the developer's application, Haringey commissioned an independent equalities impact assessment, which recommended that to minimize adverse equalities impacts, Haringey should seek to ensure that the development provided retail units aimed at local traders, a new site for the existing market, and financial assistance for traders relocating from the existing market to the new market. The assessment also recommended that Haringey should seek to ensure that the developer helped to identify a location for a temporary market during the development process. Haringey granted the developer a new planning permission in July 2012 for the demolition of existing buildings and the construction of apartments, a new market hall, and other retail units. Haringey sought to implement the recommendations in its equalities impact assessment through the Section 106 agreement it made with the developer. The report that a Haringey planning officer presented to the council's planning committee recommending the grant of planning permission noted, however, that the council would only minimise negative equalities impacts if all the measures set out in the Section 106 agreement are honoured in full and in a timely manner. So, Haringey and the developer used the Section 106 agreement instrumentally to support the council's performance of its equality duty. And this provides a valuable insight into the contract behaviours running through Section 106 agreements. These agreements can be designed to enable LPAs and developers to navigate potential legal challenges and reassure third-party onlookers about the way an LPA and a developer are conducting the development process. But there's a bit more scene setting I need to do regarding this development. At the outset, a range of different individuals, businesses, and other organisations separately owned the land that constituted the Seven Sisters site, as I said a moment ago. By 2016, the developer controlled almost all that land. To enable the developer to acquire the outstanding land interests, Haringey made a compulsory purchase order, a CPO, to force those landowners to give up their land in exchange for financial compensation. Some landowners objected. A group of market traders and their supporters also objected because the proposals would lead to the closure of the existing market. And these objections triggered a public inquiry into the proposed CPO. To secure confirmation for the CPO, Haringey argued that the development would provide well-designed open space and amenity areas, upgrade local housing and retail offerings, contribute to the overall character and significance of historic buildings in the area, reduce unemployment, catalyse economic growth, and guarantee the provision of a better market hall for the area. Many of these purported benefits were also the developer contributions theoretically secured in the Section 106 agreement. Haringey accordingly presented the Section 106 agreement at the public inquiry to justify its proposed use of compulsory purchase powers. Now, quite a few years ago, Paul Winter and Richard Lloyd explained how local authorities seeking to obtain confirmation for a CPO would be well advised to make proper arrangements as far as reasonably practicable to relocate displaced businesses, residents, and other occupiers, and to provide assistance in that process. To that end, Haringey and the developer proposed and then agreed various changes to the Section 106 agreement during the public inquiry. By this point in the development process, the developer had agreed to provide a location for the temporary market during the development process, and the modified agreement created additional developer obligations relating to this temporary market and to the new permanent market. This is another example of using a Section 106 agreement to signal an attempt to safeguard the public interest. To function as a helpful artifact at the public inquiry, these commitments needed to be substantial enough to travel to the inquiry to reassure the planning inspector chairing the inquiry about the appropriateness of the development proposals. In fact, the Section 106 agreement didn't impose an absolute duty upon the developer to provide a new market. I've put the relevant provisions on the screen. The market condition referred to here means the receipt of an offer from a market operator to enter into the market lease. The agreement only obliged the developer to use reasonable endeavours to lease the new market to a market operator who would be responsible for the day-to-day management of it. If the developer hadn't received an offer to run the market from a market operator that it deemed suitable, or if it hadn't entered into an agreement to grant the lease, the developer wouldn't be required to provide the new market. But that said, I don't think the overall agreement is very clear on this, because it seems to me that the agreement separately states that the developer couldn't close the existing market until the temporary market is ready for occupation. But the agreement then states that the developer can't close the temporary market until the new market is ready. Compare that to what I said a moment ago. The developer wouldn't have to provide the new market if it couldn't find a market operator to whom it would lease the market on commercially acceptable terms. So would the temporary market have to remain in place if the developer never entered into a lease for the new market? I don't know. The intended effect of these provisions isn't entirely clear to me. You know, I might be wrong. I might have missed something, but it doesn't seem entirely clear. I think the intention was probably that the developer could decide if Seven Sisters would have a new market. And that's not surprising. That was the intention. There's nothing unlawful about that. That's what you'd expect if you ask a profit-driven commercial entity to provide this particular service. And the inspector, chairing the public inquiry, concluded that the developer obligations in the modified Section 106 agreement adequately secured the future of the market and provided sufficient assurance that adverse equalities impacts would be minimized, notwithstanding the absence of any, using the inspector's words, cast iron guarantee that the developer would provide a new market. As I said earlier, that's what you'd expect if you task a private actor with providing an ostensibly public service. And the Secretary of State reached similar conclusions to the planning inspector and confirmed the CPO. The inspector's report and the Secretary of State's decision letter are notable for the way in which they express confidence that Haringey will use the powers in the modified Section 106 agreement to perform a safeguarding function on behalf of the local community. The market traders were less convinced. Other research has considered their opposition to the proposals and discussed how they formulated alternative development ideas. The traders had protested throughout the planning and compulsory purchase process that even if Haringey could make the developer comply with the rental scheme for the temporary market and the new market as set out in the modified Section 106 agreement, that scheme was poorly conceived and would be unaffordable for the traders. The traders also pointed out the apparent emptiness of some developer obligations, including the obligation to promote local independent traders in new development. From the traders' perspective, these arrangements implied that Haringey's commitment to protect their interests wasn't entirely credible. And the different perspectives held by the market traders show us how legal frameworks can function in planning processes to prioritize certain interests while seeking to constrain the capacity of other interests to influence decision-making. Haringey and the developers persuaded the decision-makers who mattered, and the Section 106 agreement helped with this. So this Section 106 agreement helped de-risk potentially problematic equalities and land acquisition issues. But these seem to me to have been loosely worded obligations involving somewhat empty commitments. So we should ask, therefore, if this type of arrangement is an appropriate mechanism for attempting to secure developer obligations. And like I said earlier, we could think about monitoring and enforcement when we consider this. Because this development shows how monitoring and enforcement can prove problematic. In 2019, Haringey reviewed its monitoring and enforcement of the developer's planning obligations and found that evidence suggests, and I'm quoting, that the developer had possibly breached obligations in the original agreement and the modified agreement. The first apparent breach involved an obligation in the original agreement requiring the developer to report to the council biannually on efforts to identify a location for the temporary market and to promote the interests of the existing traders. And this review established that neither the council nor the developer had any record of these reports being written or received, although it did note that it had been discussing the location of a temporary market during this time. The two parties had been discussing this, albeit possibly not in accordance with the very strict rules for doing so set out in the Section 106 agreement. But the council concluded if there was a breach, it hadn't continued because the modified agreement had removed this biannual reporting requirement. So that was the first possible breach in the council's, discussed in the council's review. The second involved an obligation in the modified agreement relating to a market facilitator. The developer had already appointed this market facilitator, and the modified agreement obliged the developer to procure that this market facilitator provided, amongst other things, appropriate business support and advice to all market traders and persons working at the existing market. But, to quote from Haringey's review, the relationship between the market facilitator and the traders had broken down, meaning that the market facilitator couldn't promote the traders' interests and that the traders' obligation, again to quote, was not complied with once the developer became aware. That breach, however, the review concluded, was also not ongoing at the time of Haringey's review because the original market facilitator was no longer in post. But there was seemingly some sort of problem here. Part of the problem may have come from evident uncertainty reflected in these reports within the council about when certain obligations took effect. According to a separate review that Haringey's Overview and Scrutiny Committee conducted, Haringey's legal department had initially told the market traders' legal representatives that some developer obligations in the modified agreement relating to the market facilitator only took effect when the developer started building. It appears that Haringey later backtracked from that position and agreed that these provisions took effect from the date that the parties signed the modified agreement. And that later position certainly seems to me like the correct interpretation of the provisions in the agreement. So it appears that there was genuine uncertainty in the council about the powers that the council had. And according to the Overview and Scrutiny Committee, Haringey's Assistant Director for Planning felt that the council's regeneration department had not alerted the planning department to the apparent breach of these market facilitator obligations. And that absence of information might have been because the regeneration department had followed the legal department's advice that the provisions were not yet in force. But the assistant director had also not investigated this because the report explained the assistant director had felt it necessary for her to keep separate from the CPO inquiry. And this perceived need for separation arose presumably because close involvement by the planning department in the regeneration department's land acquisition process might have led to an allegation that the planning department's decision-making on planning matters was no longer impartial. But the Section 106 agreement was a planning agreement with obligations that the planning department could theoretically monitor and enforce. And an obligation that an LPA and a developer enter into, but which the LPA is hesitant about investigating, might begin to look like a symbolic gesture rather than a binding commitment. Now, I'm picking up on some potentially problematic aspects of these council reports. I should mention that Haringey has stated that it does not consider that there was a failure to monitor the Section 106 agreement. But there might be some things that we can learn about Section 106 agreements more generally from looking at this one. I'll come back to that in a moment. I will talk about that. I'll come back to that in a moment. First, I want to mention that in August 2021, the developer announced that it was abandoning the development because, I'm quoting again, of the drawn-out nature of implementing the scheme owing to numerous legal challenges from a small but vocal minority. But screenshot of the developer's press release on the slide here. Part of this small but vocal minority had been arguing, of course, that the developer's proposals would be likely to have negative equalities implications because of the effect on the existing market. Disputes about property development proposals often disappear behind the neatly ordered technical documents ostensibly formulated in the public interest to move the development process along. The market traders and their supporters subverted this tendency in the context of this development by opposing the developer's proposals in a sustained and coordinated manner, but it's rare for civil society campaigns to achieve this sort of outcome, so it's likely that similar contract practices are overlooked where community concerns are not as effectively represented. Now, I should add that Haringey is proceeding with new development plans for this site. They've highlighted in their publicity materials how they're seeking to do this in a collaborative, inclusive, and community-oriented way. But like I said a moment ago, I want to conclude by thinking about broader lessons to be learned. And the first observation that I have is that we need to think carefully about how LPAs exercise decision-making powers in pursuit of their definition of the public interest. I've been talking about two types of Section 106 agreement. One was utterly mundane and designed to secure the delivery of everyday planning obligations. The other involved a more unusual set of Section 106 arrangements drawn up and modified to show a local authority was minimizing negative equalities impacts and to justify its use of compulsory purchase powers. And these Section 106 agreements illustrate similar things. They each consist of administrative clauses that look highly discrete and that create an intricate and apparently prescriptive framework of rights, responsibilities, duties, and powers. In the case of the Seven Sisters development, a modified Section 106 agreement created contractual safeguards that were loose and vague, yet substantial enough to justify a CPO and to demonstrate that an LPA had discharged its public sector equalities duty. This reflects the way that Section 106 agreements don't just govern the relationship between an LPA and a developer. Instead, these Section 106 agreements have diverse and multi-layered roles in shaping regulatory processes and wider community relations. And this is important. An intricate framework of rights, responsibilities, duties, and powers which have the trappings of a contract can enable LPAs to enact their version of public interest despite the apparent emptiness of some of the provisions. In the case of the Colchester development, the Section 106 agreement created a detailed route map for the delivery of developer obligations. But the complexity and apparent rigidity of this route map belies the one-sidedness of some of those arrangements. So looking inside Section 106 agreements should cause us to think about how the English town planning system empowers different actors to take decisions in the public interest despite contested definitions of what that public interest might entail. It's already well known that relying upon private companies to deliver public policy objectives produces uneven outcomes and marginalizes certain interests. While the Section 106 agreements studied here are a product of the transfer of decision-making powers over public service delivery to private companies, they also illustrate how legal frameworks reinforce this dynamic. And a particularly acute legal problem highlighted here is the way that complex drafting might mask the emptiness of some of the contractual safeguards that Section 106 agreements purport to create. If introduced, the government's proposed infrastructure levy may affect this dynamic, although those proposals, like I said right at the beginning, foresee an ongoing role for planning obligations secured by Section 106 agreements. So we need to be aware of what the detailed drafting in these Section 106 agreements is and is not doing. The agreements studied here look like substantial contracts designed to hold private developers to the performance of public policy objectives. They establish reference points and procedural safeguards that create the impression that there will be active LPA monitoring and enforcement of the developer obligations. But I think that closer examination of these reference points and safeguards can suggest that these safeguards may not and cannot always work that way. Perhaps we need to think again about what Section 106 agreements are designed to achieve and how negotiation, monitoring, and enforcement practices might change to enable different outcomes. So that's pretty much everything I'm here to talk about. I'm happy to open the floor for questions if that's what we're going to do next. So yeah,
Thank you very much. Thank you. Thank you for such a stimulating talk and many different aspects I think we might want to pick up. So to open the floor to questions, I think Maria has a roving mic.
Yes. That's okay. Over here. Yeah.
Thanks very much. That was very interesting. Was there any attempt to invoke the Human Rights Act in relation to resolving any of the contractual issues? And if not, could there have been recourse to the Human Rights Act?
Yeah, interesting question. In terms of sort of resolving the contractual issues, it's sort of, I mean, interesting framing it as, you know, interesting thinking about it in terms of contractual issues. I mean, there certainly was, you know, a lot of discussion in that particular development process about human rights issues. Special rapporteur from the UN at one point contributed their views. There were lots of discussions broadly speaking, relating to human rights issues and that in the context of that development. But yeah, it's an interesting way of thinking about it if there was sort of any kind of human rights considerations in relation to the contract specifically. I think that's something I'd like to think about. That's the way in which there might be those two things might intersect. That's a good question. Thank you.
Yeah. Thank you for the presentation. It's very interesting. I just had a question because obviously like Section 106 agreements are used in everyday planning in England. But I was also thinking, and I think you addressed this in some of your other work, I think among other things in the Colchester analysis of the Colchester development, what the role is of other types of contracts. For example, I think you cite also Section 1 of the Localism Act or Section 111 of the Local Government Act, which do not have to, there's no obligation to make them public in the same way that applies to Section 106 agreement. So I was just wondering, what do you think is the part played by these sort of less ostensible or less accessible contracts in everyday planning, because they are coupled with Section 106 agreements to sort of maybe hide something from view? And I was just wondering what is the importance, qualitatively and quantitatively in everyday planning?
Good question. I mean, I don't know how you would quantify that. I certainly I suppose the way you quantify it is by going out and asking questions and doing the empirical research. No, it's a really good question. I think, you know, the distinction, one of the key distinctions between Section 106 agreements and other types of agreements is that Section 106 agreements have the potential to bind the land. So obligations in the Section 106 agreement can bind a current landowner and a subsequent landowner in a way which might be different to other types of agreement. I mean, there are a whole range of different types of contractual arrangements that a local authority and a developer might enter into. You know, there's Section 278 highways agreements, a multitude of different agreements. I suppose I don't know the answer to your question, but I think that would be a really interesting thing to find out more about. Where I've sort of, you know, stumbled across a network of contractual arrangements that go beyond the Section 106 agreement, it really is because I've sort of stumbled across it. I've been looking at, you know, local authority documents, and I've seen something interesting about there being other agreements made under different statutory powers that might relate to a particular development. So yeah, my knowledge there is not particularly detailed. What I have found out about those sorts of things, I found out through chance, really. So I don't know the answer to your question particularly, but it's an important thing to investigate, I think.
Thank you very much. I think it was very, very interesting. And I'm coming from a planning perspective. You used the word flexibility a lot in your talk. And I have a question which goes much beyond, in a way, your presentation. I'm really interested if you have a view and intake on how Section 106 take into account crisis, disruptions. And for example, typically when we're looking at what happened during the pandemic, it was the time where planning went beyond, in a way, regulation, where there's a lot of health emergency measurements. And I'm just wondering, what is your take on this? And what is the flexibility in time of crisis that is allowed? And if you have, any view or any examples of this?
Oof. God, I'm being put on the spot here. The limitations of my knowledge are becoming painfully clear. I don't think I do have any examples of that. That's a really, really interesting thing to think about. I suppose both these developments, I'm not sure quite what the right term is, started, were conceived before the pandemic, but then the pandemic naturally affected aspects of them. The Colchester one, I think the Colchester one, certainly the planning application and those sorts of things, I'm sure those would have predated the pandemic. I don't think the pandemic had any material effects on that one. And the other example, the Seven Sisters case study, by the time the pandemic came round, I think it was probably headed in the direction of the press release, which I showed. So in terms of specific examples, that would be a fascinating thing to investigate. Yes, and I'm afraid that's all I can offer in terms of specific examples.
Hi.
Oh, yes, hi there.
Thank you so much for the presentation. So coming from a contract background, one of the things I thought was really interesting was your distinction between sort of contractual behavior and contract and its substance. What came to mind as you were going through your presentation was the idea of privity of contract, which means obviously that third parties are essentially excluded from being able to have a say in the agreement itself. And so to what extent, I suppose, in your sort of travels and investigations, did you see words like stakeholders being mentioned, or you know, sort of access to sort of challenge and those kind of mechanisms being built into the contract itself? Because I think to some extent the substance can help to bridge the practice of contracting and make it a little bit more legitimate and substantive.
Yeah, okay. So in terms of So in terms of what you're wondering about stakeholders, are you sort of thinking about that in terms of the contract documents themselves?
Yeah, so I think in potentially for example, the investment world, there are sort of built-in clauses where you have to sort of consider stakeholders and bring in stakeholders to sort of advise on certain things. And those tend to then generate conversations around what is meaningful and what is not. So I guess, have you come across that sort of thing?
Certainly, yes,
Okay.
certainly there are, yes. So the market facilitator clause that I talked about in the Seven Sisters example, I think would be an example of that. It's sort of a contract where the two parties are deciding how they're going to shape the interactions between people who aren't a party to the contract at all. So it's not one of the contracting parties, necessarily engaging with external stakeholders, but a market facilitator who's not a party to the contract, how they're going to engage with the existing traders. So it's sort of there are clauses, talking about that sort of thing. In the other example, the more mundane example, I can't really think of many clauses there which sort of mandated any external engagement, because in planning processes, all that sort of consultation would take place as part of the planning application rather than as part of the negotiation or implementation of the agreement. So so this is all happening within a context in which there are other consultation mechanisms and public participation mechanisms in place.
Thank you very much. I was wondering, I was surprised when you were going through, especially the first case, when you were talking about the different milestones that the Section 106 agreement was establishing as a way of monitoring the delivery of the project by the developer. And it did sound super ambitious and detailed, and in a way it showed like a big ambition from the local authority to control to a very detailed level the developer's actions. And at the same time, we know that local planning authorities are short of staff. And so it kind of was surprising to see a level of ambition in the writing of that contract when you then put it in against the lack of staff in the planning departments. And your last question, like how can revisiting monitoring of these Section 106 agreements could improve? I was wondering whether in your empirical research, you did find that perhaps that mismatch between the level of ambition in the details of Section 106s and the realities of the amount of staff monitoring, skills in monitoring. I don't know. I would like to know more what were your thinking and your findings around that.
I mean, I would like to as well, and I think that's what I'd like to do next. I think I sort of am just at the stage of sort of similar to you, looking at these contracts and thinking, wow, what's all that there for? What's all that doing? And so yeah, I mean, I would love to do that next, I think.
I'd be really interested to read it. Thank you.
Hi.
Oh, yes, hi.
I was really interested to hear your perhaps assumptions, but I might be wrong, about the interests of the developer,
Right,
and what they were pursuing in both of these projects. And is that derived from the way in which they conducted themselves in the Section 106 agreement, or is it a more general assumption about what developers are seeking to do?
Yeah, I think I don't have in terms of the cold chest development concrete evidence about what that particular developer has done. So I think you're probably I was going to say what you're saying is a fair assumption, but you're using the word assumption. I think you're right that I was sort of making a general assumption, sort of I suppose I was generalizing about what those types of clauses might do for a notional developer rather than necessarily for those specific developers. And I was sort of drawing that from other research. But again, that would be another, fascinating thing to sort of sit down with developers and talk to them about what they're doing with these clauses, what those clauses mean for them. It'd be a fascinating thing to do. So I could do more than just make assumptions.
Okay, so that was fascinating, and we started with law, and we sort of worked all the way down, and we had a nice discussion of games people play in the context of a legal framework. So let's reverse the dynamic, and let's appoint you policy advisor to a new Labour government after the UK general election. In the light of what you've learned, is there a case for amending, revising, whatever, Section 106, the legislation itself? And if so, in what direction would you take it?
I mean, that's not something I've really thought about. Yeah, again, the limitations of what I've thought about are striking me. Would I amend Section 106 itself? I mean, I think, like I said at the outset, I can see how contract and contract mechanisms has the potential to provide, there's things I talked about, administrative efficiency, potentially enforce and creates enforceable obligations. Local authority has a mechanism for enforcing those. So reforming Section 106 itself, I don't have a suggestion for reforming Section 106.
Well, let me be more specific. Are there certain things you might like to rule into Section 106, and are there certain things you might like to rule out using Section 106?
Well, I think Section 106 creates. I talked about how Section 106 talks about binding land in perpetuity. If you want to create obligations that are binding not just against the current landowner or the current developer, but against future landowners, future developers, that's extremely important. Section 106 does also give, like I say, a mechanism for enforcing those obligations, albeit that, like I said, some of those obligations in those agreements, it's difficult to foresee how a local authority would, or when a local authority would ever seek an injunction relating to that. So yeah, there are some aspects of it which I think are valuable. So I'm primarily interested in how that is being used. So that's probably why I don't have any kind of specific thoughts on, removing Section 106 entirely or, amending it particularly. The risk of sounding like a broken record, that's an interesting thing to think about further when I'm got a bit of space and time to think about it. It's an interesting question.
Okay, I think it might be a good time to draw the discussion to a close. I mean, I think there's a wider question, I think for myself and others here as planning scholars, about the extent to which it is even possible to codify a public interest. I find it a fascinating question, and the things that you're bringing out, Ed, in the talk were about a kind of utopian realist model, but somehow you can capture everything about development and a planning process through a contract, and all you need is a better contract or a bigger contract. And I love that discussion of the way in which a utopian way of thinking underpins an entire approach to how planning could be and an expansion of it. And as you were saying, that paradoxically the emptiness of some of that within that. It's a fascinating discussion. So thank you for that. It's very, very thought-provoking, I think, for all of us. And it raises a whole series of areas for more research and more work, as good research always does. So on behalf of all of us, could I thank Ed for a stimulating talk and lively talk, and it's a chance to hear. Thank you very much. And thank you to Maria for organising the event as well. Thank you, Maria.